Get on the train before it leaves the station. The truth train is coming, gonna run them down,
All right, hello there, everybody. How you doing? Okay, so we're here tonight talking about Brendan. Okay, so this is an interesting paper. Obviously, you guys saw me in the past. I went through the amicus briefs that were filed for Brendan. I actually went through the one that was filed by Wicklander Zawalski back when it was filed with the Seventh Circuit Court, because they filed theirs back then. And then, you know, when they were petitioning SCOTUS, that I went through them. There were 6 of them. And I went through them and stuff like that, and kind of picked out some of the really best bits in them and stuff like that. Well, one of them was from the American Psychological Association. Okay, and one of the people contributing to that was a gentleman named Mr. Kassin, PhD, and he was part of that. You know, that I guess team, you might say, that wrote that amicus brief for the Supreme Court of the United States. He also wrote an article in the American Psychological Journal, I think it is, but basically it was an article written to basically say why SCOTUS, or the Supreme Court of the United States, should take Brendan's case. And it was basically, it's on June 12th, so it's just shortly before they were going to make their decision of whether or not to take Brendan's case. So what we're going to see here today is that article, and then we're going to go ahead and read it and go through what he says. Mainly what he gets at here, because obviously what's his expertise? His expertise is psychology. So what he goes about doing here is pointing out the psychology of this, and basically using previous Supreme Court precedent to point out some of the flaws here, and how the on-bank review, or the judges there, and the majority judges there, were not, they're basically, their consideration of the totality of the circumstances was flawed. And I agree, because you can't acknowledge that all of these things that they did to Brendan are things that contribute to a false confession, and then not give them that weight, right? Especially when you consider a lot of the things, like he points out here, the fact that the entire confession is fed to him and suggested to him by leading questions and things like that. And in fact, his final narrative is just so riddled with inconsistencies and actual factual errors that also contributes to its ridiculousness, essentially. So it's very interesting stuff. So we're going to go ahead and go to that article now, which is very interesting, and then we'll come on back. All right, here we go from the American Psychological Association, June 12th of 2018, which is just before SCOTUS basically denied Brendan's petition. This was written to encourage them to take his case. So it's written by Saul Kassin, PhD. He's, obviously one of the authors for the amicus brief that was filed in favor of Brendan with SCOTUS. Okay, so it's why SCOTUS should examine the case of making a murderer's Brendan Dassey, by Saul Kassin, PhD. Any day now, the U.S. Supreme Court will consider whether to weigh in on the case of Brendan Dassey, convicted co-star of the 2015 Netflix documentary Making a Murderer. The court should review the case because it raises many troubling issues about coercive techniques used on a vulnerable teenager, a population the court has protected in the past. This is Dassey's last chance. A federal judge overturned Dassey's conviction in 2016, ruling that his confession was coerced. A 3-judge panel later affirmed that ruling. This past December, however, by a 4-3 vote, the Seventh Circuit reinstated his conviction. If the Supreme Court chooses not to hear the case, Dassey will remain incarcerated at least until 2048. For what it means to juvenile justice, police interrogations, and false confessions, this case is troubling. The underlying psychology is highly relevant. That's why the American Psychological Association submitted an amicus brief urging the court to review it. As inconceivable as it seems, people under pressure confess to crimes they did not commit. The Innocence Project reports that false confessions contributed to more than 25% of its 356 DNA exonerations. So that would come out to about 75, 80, about almost 90 of those 356. Yeah, interesting. Innocent people don't send themselves to prison in a random act of self-destruction. So why does this happen? Some individuals are inherently vulnerable. Certain police interrogation tactics are coercive. Combine the two sets of risk factors, and false confession is often the result. This brings us to Dassey of Manitowoc County, Wisconsin. On March 1st, 2006, Dassey, then 16, sat for hours in an interrogation room. Prosecuting a murder case against his uncle, Stephen Avery, two detectives wanted Dassey to implicate Avery in the murder of Teresa Halbach. Eventually, he succumbed, implicating both Avery and himself. The Seventh Circuit evaluated Dassey's confession by considering the totality of circumstances under which it was taken. In reinstating Dassey's conviction, however, the court's totality analysis was flawed. While conceding the existence of specific risk factors, it failed to account for how these factors interact. One issue concerns Dassey's susceptibility. Over the years, the Supreme Court has cautioned that juveniles should be treated with special care. Youth are vulnerable, which is why juveniles are statistically overrepresented in false confession cases. They are more easily manipulated than adults, more compliant, and more myopically focused on the present. Citing development neuroscience, the National Institute of Mental Health has described the teenage brain as a work in progress. Dassey also has below average intelligence with a tested IQ of 73, making him even more vulnerable in the film. He described himself as stupid. "They got to my head," he confided to his mother. Research shows that people who are intellectually limited do not fully grasp their Miranda rights or the grave consequences of confession. They are also highly suggestible to leading questions. A second set of issues concerns the processes of interrogation used on Dassey. Rather than compensate for the boy's limitations, police used the kinds of trickery and deceit that can produce false confessions from fully functioning adults. Detectives said they knew what happened and had proof, which was untrue. When the boy protested his innocence, they pressed on and threatened to charge him. Research shows that misrepresenting evidence can disorient people. It can alter people's perceptions, beliefs, memories, and even certain medical outcomes, as in the classic placebo effect. Yet U.S. courts permit police to lie to suspects about DNA, fingerprints, or failed polygraph. This tactic is rampant in adult confessions. In the laboratory, it leads innocent college students to apologize for breaking a computer, cheating, or stealing money. Detectives also offered Dassey a lifeline and sought Dassey's trust by pretending to care for him as they would their own sons. "I'm a father that has a kid your age," one detective said. "I promise I will not leave you high and dry." That subterfuge set the stage for the police to introduce calming minimization tactics, feigning sympathy. They suggested that Avery, not Dassey, was to blame. U.S. courts normally reject confessions induced by explicit promises of leniency. They recognize that an innocent person feeling trapped and told he has nothing to lose might be tempted to confess to something he didn't do. To be sure, Dassey's investigators made no specific promises, but leniency was strongly implied. "It's not your fault. Remember that," they said. "You've done nothing wrong." Research shows that when a friendly interrogator assures a suspect in this way, people infer leniency, as if a promise has been made. This might explain a head-scratching juxtaposition in which Dassey both admitted to murder and asked if he would get to go back to school in time for a project. The Seventh Circuit cited 3 arguments in support of Dassey's confession. First, it noted that Dassey was not subject to physical force or mental exhaustion. He wasn't handcuffed, yelled at, or beaten into submission. This is true, but setting the bar this low and represents an incomprehensible step backward. Even the Miranda court over 52 years ago understood that a subtle psychological approach can be inherently coercive. The second argument was that Dassey waived Miranda, that he nodded in agreement, and this constituted prima facie proof that his ensuing statement was voluntary. This is only half right. Dassey may have nodded, but the gesture more likely conveyed the acquiescence to authority of a low IQ teen, not agreement to waive his constitutional rights. Research shows that individuals who did nothing wrong don't think they need protection. The third argument was that Dassey's confession showed that he had corroborating knowledge about the crime. Not so fast. Dassey's final narrative was riddled with inconsistencies and factual errors. Moreover, the detectives had fed him information through a series of hints and leading questions. As in many proven false confession cases, he merely parroted a statement authored by investigators. On this point, too, it is worth noting that fully 95% of proven false confessions contain accurate and often vivid facts about the crime that were not in the public domain. Facts communicated to innocent suspects through the process of interrogation. Over the years, the U.S. Supreme Court has sought to protect children, recognizing that they require special care. The treatment of Brendan Dassey, using interrogation tactics built for adults and troubling in their own right, controverts this position and should be re-examined. So there you have it, in the words of Saul Kassin. And, you know, that's looking at the psychology of it. And remember, psychology was just one of the briefs. You know what I mean? There was briefs filed by law enforcement, like chiefs of police and law enforcement trainers, and you know, we had professors of law that were filing a brief on this. We had, I mean, just so many different things. It was powerful to see all these different parts of the criminal justice system weighing in on Brendan Dassey and recognizing it for what it was. But SCOTUS let it slip. I mean, I'm so disappointed in the Supreme Court for letting it slip. I mean, juveniles need a path right now. We need the federal judges to be able to keep the state courts honest with juveniles, because they can't seem to regulate themselves. That's why things like with Brendan Dassey are happening in all over the place. When everything tells us that that the methods used here were bound to end up in a false confession, when we know that Brendan's suggestibility and his low IQ sets the stage for a false confession, when we know all these factors are here and present, and yet AEDPA ended up in the end being what stood in the way of this, and it shouldn't have. And the Supreme Court is in a big way responsible for the fact that Brendan's habeas was denied, because of the way that the Supreme Court interpreted AEDPA. They decided to remove all of our habeas rights, everybody's. Right? Well, you know what? Juveniles in our criminal justice system need theirs back. And that's what SCOTUS could have done here, in my opinion. And I gotta say, very, very, very good article there from Saul Kassin. Just, you know, like I said, weighing in on the psychological aspect of it, which is really only just one aspect of it, right? So, I mean, you remember there was former prosecutors that weighed in on this. I mean, there were so many, these amicus briefs were so full of just powerful content. I encourage people to go back and look on my channel and search my channel for the amicus briefs and check out if you haven't seen them before, because they were very powerful and they were very interesting. So, all right, folks, if you haven't already, please hit subscribe, and we'll see you.